The court will call D1GN 26-002511 to order. Counsel, there were some additional items you wanted to discuss with regards to the exhibits. So let's start with the state.
Defendants would ask that their defendant's demonstrative 1 be attached to the record.
Okay, do we have any objections to that?
No, Your Honor.
Okay. That is in the folder listed as demonstrative 1, and that's going to be admitted for that purpose as a demonstrative
Thank you, Your
for the
Honor.
record. And on plaintiff's side, Ms.
Yes,
Taylor.
Your Honor, we request that plaintiff's demonstratives number 1, 2, 4, 5, and 6 be attached for demonstrative purposes only in the reporter's record.
Are there any objections to that?
No objections, Your Honor.
All right. And that was 1, 2, 5, and 6.
And 4, Your Honor.
And 4. So those will be attached as requested. Specifically, 3 is being left out.
That's correct, Your
All
Honor.
right, got it. Thank you.
Thank you.
All right. You may call your next witness.
May I approach the podium, Your Honor?
You may.
Defendants call Dr. Timothy Stevenson.
Good morning, doctor. Please raise your right hand. Do you solemnly swear and affirm under penalty of perjury that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated, sir. There's water if you need it. You just need to push that button to turn on that microphone. There's a little gray button. Okay. Oh, it's off. It's actually off. There it is. If you need fresh water, there's cups for you there. You may proceed. Look up at the lawyer when you're ready.
Yes.
Zachary Berg for the defendants. Good morning, Dr. Stevenson.
Good morning.
Would you please state and spell your name for the record?
Timothy Stevenson, Timothy Stevenson.
What is your educational background, say starting at bachelor's degree?
A bachelor's in science, a doctorate in veterinary medicine, and a PhD in food science and technology.
What is food science and technology?
It's a broad degree dealing with food microbiology, food chemistry, food processing technology, all aspects related to food production, and in the area that I specialized in was public health and food safety.
Are you currently employed?
Yes, sir.
What is your current employment?
Work with the Department of State Health Services.
And how long have you worked for Dishes?
7.5 years, and yes, sir.
What is your current title?
I'm the Deputy Commissioner for Consumer Protection.
And at a high level, what are your current responsibilities?
Consumer protection, we work with a lot of programs dealing with public safety, so emergency medical services, radiation, environmental compliance, dealing with asbestos, lead issues, meat safety, and then our food and drug division deals with a lot of commodities under that umbrella.
And how long have you held that role?
5 years.
Prior to working at Dishes, where did you work?
Worked a few years in the Army, U.S. Army Veterinary Service.
Approximately how many years?
29. Almost a career.
Did your role in the Army include any duties related to laboratory work or health inspections?
Yes, sir. That was one of my areas of focus was laboratory testing and food safety programs.
And could you describe those duties generally?
In various aspects, I started as an auditor, inspector, veterinarian as well, dealing with clinical aspects, and then through deployments and additional training, more specialized in the public health, and then developing programs, writing program of policy, training, recruiting, all aspects of those components. Really protecting the troops from diseases that could come by food or zoonotic diseases, animal diseases that are shared between animals and humans.
In your current role as Deputy Commissioner, do you oversee laboratory work or health inspections?
Current role, we have laboratory testing with several of our programs. We develop and implement testing schemes that are appropriate for the products.
The court has heard a little bit about this topic, so I'll cut this a little shorter. I'd like to talk about the chemicals found in cannabis plants, specifically the differences between THC, Delta-9 THC, and THCA. What is THC?
Tetrahydrocannabinol. It's a compound with 3 rings, rich in carbons, so it's fat soluble, lipid soluble, and a specific compound under that. There are several specific compounds under that umbrella of THC.
Is one of those compounds Delta-9 THC?
Yes, sir.
What is Delta-9 THC?
A specific formula of THC, specific compound and structure that is unique for that THC.
Are THC and Delta-9 THC found naturally in cannabis plants?
Yes, sir.
Do all cannabis plants have the same level of Delta-9 THC?
No, sir.
Do all cannabis plants have the same levels of cannabinoids from planting to harvesting?
No, sir. There are different varieties that farmers can choose from that will tend to have more THC, various types of THC. Some might have more cannabidiol. And then those precursors, THC acid is a precursor to THC Delta-9. So at different points in the plant's maturity and the process of the plant, you might find more or less THCA as it's converted to THC Delta-9.
Is Delta-9 THC psychoactive?
Yes, sir.
What does it mean to be psychoactive?
Has an impact on the central nervous system, on the brain, the mind, so it affects mood and mental states.
Why is it important that the state regulate psychoactive substances?
Because of the impact on the central nervous system and our nervous system, our functioning, our neural cognitive abilities, and moods, and our central nervous state, the state of our mind. And so those psychoactive products can have an impact on our mind.
And then, so what is the difference between THCA and Delta-9 THC? Chemically.
I would object to Life Foundation for this. I don't think he's qualified to actually make that. I don't think we've had his educational background. We don't know what coursework he's taken.
Want to respond?
I can lay the foundation.
Alright.
That's fine.
The objection is sustained.
Are you familiar with the chemical makeup of Delta-9 THC?
Yes, sir.
How did you gain familiarity with that?
Reading published literature.
Are you familiar with the chemical makeup of THCA?
Yes, sir.
How did you gain that familiarity?
Again, studying the literature.
Is THCA found naturally in cannabis plants?
Yes, sir.
Do the different parts of a cannabis plant have the same amount of THCA?
No, sir.
What is the difference between hemp and consumable hemp products?
Hemp is the plant, and then the hemp that is harvested and tested by the Texas Department of Agriculture, they have responsibility for the plant and certain plants that meet the definition of hemp. And then when those products are moved into the food supply and become products that are consumable for customers, then that aspect of the consumable hemp products are regulated by Department of State Health Services.
If the different parts of the cannabis plant have different levels of THCA, what sort of options does that allow manufacturers when they're designing products with THCA?
Yes, sir. They may use different parts of the plant for different expectations or focuses that they're trying to achieve. So the stem has very low levels of THCA and or THC. The leaves have more of both of those compounds, and then the flower itself has more THCA and more THC.
Is THCA psychoactive in its natural state?
No.
Can THCA be made psychoactive?
Yes, sir.
How?
Heating and or drying as the product matures. It's a natural chemical process for that THC acid to become THC delta 9. Heating is the most pronounced means of doing that.
And when THCA is heated, what happens to the chemical makeup?
The THC acid differs only from THC delta 9 in that it has a very small group, a carboxyl group, a carbon with 2 oxygens and a hydrogen, very small acid group. And so when that acid group or carboxyl group specifically comes off the THC molecule, it immediately becomes THC delta 9. The two are linked in that normal chemical progression.
You previously testified about your experience in the Army working in a laboratory.
Yes, sir.
Do you have any experience with the equipment used to test for THC?
Yes, sir. I do.
What are the primary methods labs use to test for total THC?
There are two primary pieces of equipment and methods in the laboratory. One is a gas chromatograph. Shortened, the acronym is GCMS. It's gas chromatography with a mass spectrometer at the end to quantify and detect the amount of chemical analytes. So GCMS is a gas, and the other primary method is liquid chromatography, LCMS.
Let's take those in turn. Gas chromatography, how does this test accomplish measurement of total THC?
It heats a sample so that chemicals that can become a gas do become a gas, volatile chemicals like the cannabinoids. So those are heated, and then the cannabinoids, the THC that are there, will go into a gas form, and then it tests the amount of those products and measures those at the end with the mass spectrometer. So gas.
What is a mass spectrometer?
It's an implement in the laboratory that's highly sensitive to detect the amounts of compounds as they are going. The compounds are separated in a column, and then once they go to the detector, it actually detects the mass of the compounds and the analytes that are there. So it measures the amount of THC or specific compounds that you're looking for.
Using gas chromatography, at what ratio does THCA convert to delta 9?
87.7%.
And then you mentioned liquid chromatography. How does this test measure total THC?
Yes, sir. It leaves the sample in a liquid form, so it's not heated to an extent that would vaporize chemicals that you're looking to detect. And so that's the primary difference, is it separates but leaves the sample in a liquid form, low heat.
If it doesn't vaporize the
Right.
THCA, how does it measure total THC?
It would keep the two THCs and other THCs separate because there's no heat to the extent that it would convert THC acid to THC delta 9. So both of those compounds would be detected at the mass spectrometer at the end as individual compounds. So it would quantify and show you the amount of THC delta 9 and the amount of THC acid.
And is there any math that is involved in determining how much THCA is present in a liquid chromatography test?
Yes, sir. Simple addition. THC acid added to THC delta 9.
At what ratio?
1 to 1. It's a simple addition. I'm sorry, Counselor. I misspoke. The gas chromatography, the THC acid is converted to THC delta 9. So in that case, there's no, you don't use the 87.7% factor. It is already converted into THC delta 9. So when you measure THC delta 9 in the gas chromatograph, GCMS, you have the level of THC delta 9. With liquid chromatography, they're added, but there's an 87.7% factor, which again factors the transition and the percent of THC acid that's converted to THC delta 9.
Thank you for cleaning up my question.
I'm sorry.
Are both methods considered acceptable for measuring cannabinoids in cannabis plants?
Yes, sir. They're both standard methods in the federal standard.
Do both methods cost the same?
Liquid chromatography instruments tend to be a little more expensive, but they're both quite expensive platforms to run in the laboratory. They're incredibly sensitive and quite expensive methods of testing.
If both methods are valid, why not just use the cheaper one?
Gas chromatography, we have relied more on that when we deal historically in laboratories testing these products, food products especially, and fat-soluble products like this. We've relied more on gas chromatography. Liquid chromatography came into the laboratory testing a little bit later in the scheme, and as I said, is slightly more expensive, but a lot of laboratories still rely on gas chromatography. It's a very important testing methodology that more laboratories would have and utilize.
You mentioned testing methods required. What testing method is required under the state plan codified in Chapter 121 of the Agricultural Code?
The state plan and the federal plan both allow the use of the liquid chromatography and the gas chromatography methods.
Are there any other testing methodologies mentioned in any of these statutes or regulations?
I don't believe so, no, sir.
Is there any limitation in these statutes or regulations that specifies that these testing methods are only for use on pre-harvest plants?
The Ag Department uses it in the field on the plants, but there's nothing that specifies it should be constrained to pre-harvest.
Does Texas also rely on cannabis testing from manufacturers of consumable hemp products?
Yes, sir.
Why is testing performed by manufacturers? Why not just test at the field?
Products can change as they mature and go through processing, and then also manufacturers may mix different compounds. And then the concentration might be changed from raw materials when you take and you combine hemp from the field and other products that you're using to create your product for the consumer, those levels could be concentrated or diluted through the manufacturing process. So that helps the consumer, the end user, that helps them know the amount that's in the final product.
In your role in consumer protection, have you noticed that manufacturers are adding high levels of THCA to products that aren't heated, like gummies?
No, sir.
Why would cannabis manufacturers add substances to their products that become psychoactive?
It's calls for speculation, and we're also not based on personal knowledge, and he hasn't been qualified as an expert.
I'm asking for the witness's experience in his role in consumer protection dishes.
The objection's overruled.
Why would cannabis manufacturers add substances to their products that become psychoactive when heated?
With the intent that that product would be converted and that's delivered to the consumer. So when you said THC acid added to the product, if it were to be heated, that would immediately become THC delta 9 to the consumer.
So you talked earlier about testing by Texas Department of Agriculture. Does the Texas Department of Agriculture test for THCA?
They use the combined methods, those two methods, and it includes THC acid with THC delta 9. So yes, they do include THC acid in their testing.
Can we bring up Plaintiffs Exhibit 14, please? This should appear in front of you, but if not, I have a physical copy.
Yes, give me 1 second. Let's get it. It should be coming up in just a minute. It's a little hard to see on the screen. I'm gonna lower the lighting. Can you see it in your screen?
yes, ma'am.
Okay, I'm lowering the lighting a little bit to. Yesterday it was fine. Today it looks a little bit lighter. Is it something in your screen perhaps?
I don't believe so. My
Okay.
practice is have it.
All right, you can see it
Yes, ma'am.
clearly? Okay.
Yes, Your Honor.
Dr. Stevenson, have you seen this document before?
Yes, sir. It appears to be the governor's order, September 10, 2025. Just at the top, it doesn't give the full description yet. But it starts with Governor Greg Abbott at the top. Yes, sir. It's executive order, governor's executive order number 56, relating to protecting children from hemp and hemp-derived products and clarifying regulations pertaining to such products.
That was going to be my next question, but we'll just do a question and answer.
Yes, sir.
I'm going to refer to this document going forward as GA 56. Will you know what I'm talking about if I do so?
Yes, sir.
Was this executive order filed with the Secretary of State's office?
Yes, sir.
What is your understanding of the effect of a governor's executive order being filed with the Secretary of State?
That filing with the state gives it the implementation and effect within the state, just like our rules are filed and published by the Secretary of State.
Can we go to page 2 of Exhibit 14, which is page 1 of the executive order? So this is the whereas page, as I like to call it. Would you go to the 4th whereas, starting with in the years since House? Could you read that?
Yes, sir. Whereas in the years since House Bill 1325 was passed, Legitimate agricultural, industrial, and retail markets for hemp and hemp-derived products have developed, while bad actors have taken advantage of a dangerously underregulated marketplace.
When it says House Bill 1325, is that referring to the 2019 Farm Bill?
That's the bill that was passed by our House, Texas legislature in 2019 that was associated with the federal Farm Bill.
If we go to the next to last whereas, where Governor Abbott talks about his veto of SB 3, we've talked about that previously this week, so we don't need to get into that. Could you read from because it would not have to until responsible consumption?
I'm sorry, the very last whereas?
The next to last.
Next to last. Whereas on June 22nd, 2025, I, Greg Abbott, Governor of Texas, vetoed Senate Bill 3, 89th Texas Legislature regular session because it would not have provided a legally sustainable prohibition on access to hemp-derived products by children, did not respect the liberty of adults to access a lawful product that can be made safe through proper regulation and responsible consumption, and banned a commodity made legal by federal law.
So we have two elements there. We have protection of children and protection of liberty of adults. Could we go to next page, page 2 of GA 56, page 3 of Exhibit 14? Could you read the third whereas where it talks about DSHS's authority?
Yes, sir. Whereas the Department of State Health Services, that one? Is that
Yes, sir.
Correct. Has authority under Chapter 431, 443, and 481 of the Health and Safety Code to adopt rules to administer and enforce existing limits on the manufacture, distribution, and sale of consumable hemp products.
After the whereas ends, GA 56 goes into the actions that the governor is directing agencies to take. Could we go look at number 2A?
Yes, sir.
So DSHS is required within 10 days to do what under A?
Revising testing requirements under 25 TAC 300.301 to 300.303 to ensure that tests measure the total Delta-9 THC content of a hemp-derived product by accounting for both Delta-9 THC and conversion of tetrahydrocannabinolic acid, THCA.
So that would be the total THC formula?
Total THC Delta-9. Total THC would typically include all THCs.
Thank you for clarifying. And then could you read the direction from the governor under 2B to DSHS?
Yes, sir. Revising application and renewal fees under 25 TAC 300.202 for hemp manufacturers and hemp retailer licenses to reflect the full regulatory and enforcement cost incurred by the state.
Before the new rules, did the licenses for hemp manufacturers and hemp retailers cover the full regulatory and enforcement costs incurred by the state?
Objection, Your Honor.
What's the objection?
It's lack of foundation and also hearsay.
I'm going to sustain that objection.
Could we go to the bottom of page 3 of GA 56? Talks about the executive order superseding all previous orders. Dr. Stevenson, so we're at the bottom of page 3. Are you aware of Are you aware in your role in consumer protection of GA 56 being modified, amended, rescinded, or superseded as to any of the parts we've discussed?
No, sir.
So we can take this down. The governor specifically required dishes to update rules to ensure test measured total Delta 9 THC content by accounting for both Delta 9, THC, and THCA. Why are we concerned about the effects of THCA? What are the dangers of THCA?
THCA in itself is not psychoactive, as I said prior, but when converted in the intended form, it becomes THC Delta 9, which is psychoactive.
You talked earlier about consumable hemp products. Is THCA being added to consumable hemp products?
Yes, yes, some of them.
Jack Black Foundation and hearsay.
He oversees the inspection of this industry.
But in the way that the question was asked, and where we are right now, it is a sustained objection.
Are you aware whether manufacturers are adding THCA to consumable hemp products?
Yes.
Again, there's no foundation to this. He hasn't explained to us how he knows.
I'm gonna sustain that again.
Thank you.
Mr. Sergi, could you do me a favor and turn your microphone on? Thank you.
As part of your role in consumer protection, do you review consumable hemp products,
Yes, sir.
and do you review their chemical makeup?
Yes, sir.
In the course of that review, are you aware of THCA being added to consumable hemp products by manufacturers?
Yes.
Again, Your Honor, same objection.
Well,
Like
here
that.
he's asking if he's aware.
Based on his own experience in the course of his professional duties.
So I guess,
Well-
the question is, how is he aware?
Right, so what's missing is what is his personal knowledge? I'm gonna have to sustain that again. It's sustained.
During your review of consumable hemp products that you perform in your professional capacity, have you examined whether, not whether it's been done, but have you examined if THC is an added product to any products that you've reviewed?
Yes, sir. In the
Honor, again,
inspection.
Same objection. If you tell us how he knows that, what personal knowledge he has.
He personally inspected. He's testified.
Well, there is more foundation that needs to be laid for these questions. So you can rephrase and continue, but I think you need to go back to foundation.
When you've reviewed consumable hemp products in a professional capacity, have you ever examined the chemical nature, the chemical composition of any of these products?
Yes, sir. I've seen reports.
And what sort of reports would one examine to determine the chemical concentration of these products?
Certificates of analysis and inspection reports.
And have you reviewed certificates of analysis and inspection reports in your review of consumable hemp products?
Yes, sir.
And did your review of certificates of analysis and inspection reports of consumable hemp products evidence that THCA had been added to any consumable hemp products?
Yes, sir.
Objection, Your Honor, again, personal knowledge. Any COA that I know of doesn't state it's been added or not added.
I think he has sufficiently laid the foundation as to how he's coming up with this response, so I'm going to overrule. So you left off on reviewing the reports that he had reviewed.
Let's talk about cannabis plants. Why would breeders try to cultivate a plant with low THC but high THCA?
That would be quite difficult to cultivate a plant that it's a continuation of THC acid to THC delta 9. So that depends on the maturity of the plant and the part of the plant that you're testing. They have seeds and various serovars varieties of plants that would have lower THC acid and THC delta 9 because that's a continuum, or with higher quantities of THC acid and THC delta 9.
Why is it important for the agency to test for THCA?
Because of the conversion.
I'm going to object. This is again calling for opinion testimony, and again, we don't have a lack of foundation. Again, we're relying on hearsay.
It's an in-court statement.
Yeah, overruled.
I'm sorry, sir, will you say the question again?
Why is it important for the state to test for THCA?
Several reasons. It's tied to the definition in the Texas Ag Code and the federal bill for hemp. Those are combined in those methods. Also because of the product that's being sold to consumers. If it's heated like a smokable product, then the THC acid is immediately converted to THC delta 9, which is psychoactive.
Let's take a look at some of plaintiff's products. Could we bring up Defendant's Exhibit 001, which has already been admitted?
What was the number on this again, counsel?
Defendant's 1.
1, okay, thank you.
Are you able to read the URL at the bottom left of the page?
Yes, sir.
What does it say?
https://elevatetx.com.
And what is the header on this webpage?
Elevate Wellness Dispensary.
Can we go to page 2? Under Contact Us, who does it say that users of the website should contact?
Contact us, Elevate Wellness Dispensary, with an address and info at elevate1tx.com, and appears to be a phone number.
And are you aware whether Elevate Wellness Dispensary, doing business, Elevate Wellness Dispensary is a plaintiff in this case?
I'm not aware. Sorry, I don't have all of the plaintiffs memorized.
Go to the bottom of page 2, yeah. So it says, this week at Elevate Wellness, what does it say is the strain of the week?
The strain of the week, gas face, 50% off while supplies last.
Can we go to the top of page 3, where there's a description of gas face? Could you read the first sentence of the description, please?
If you're looking for a heavy hitter that lives up to its name, gas face. Did you say the first sentence, counselor?
Yes.
Gas face is the.
Could you read the last sentence of that paragraph? Starting with one puff.
One puff, and you'll see why it's a staff and customer favorite for total body relaxation and a clear, happy headspace.
What does this sentence suggest is the intended use for this strain of the week?
Objection, Your Honor, this calls for speculation.
It's a publicly facing website. Presumably someone, a member of the public, can interpret in their own brain what they think it means.
The objection is sustained.
How does one puff a hemp product?
I'm gonna object, this calls for speculation, lack of foundation. Don't know if he's ever puffed a hemp product or not.
Do you plan to lay the foundation for that question?
I believe the witness already testified that products can be heated during use.
But we're talking about puffing now, not heating. They're different things.
Are you aware of the term puffing as it relates to consumable hemp products?
Yes, sir.
What does that term relate to your understanding?
Smoking. Or vaping.
Can we go to,
I'm sorry, what was that second word?
Smoking or vaping.
can we please go to the first heading on page 4?
Yes.
Could you read the heading and first sentence under COA and
COA and compliance notice. And the paragraph under, is that correct?
just the sentence under?
The sentence under says, all of our products are hemp derived and undergo third-party lab testing.
And I believe we touched on certificates of analysis when we were laying foundation earlier. What is a certificate of analysis in the context of hemp seller again?
A laboratory test with the various analytes that were tested on that report.
Could you read the second sentence under COA and compliance notice?
Yes, sir. COAs, certificates of analysis, are available on our COA page.
We'll head to the COA page in just a moment, but first, could we look at Defendant's Exhibit 2, which has already been admitted?
My apologies.
Go to page 4. So we previously talked about the gas face product. Could you read the URL at the bottom of page 4, please, Dr. Stevenson?
Yes, sir. https://elevate1tx.com /THCA flower.
And so previously we talked about this, which was the strain of the week. Could we go to Defendant's Exhibit 5, please? Defendant's 5 has also already been admitted. Could you review this page for a second?
Yes, sir.
What do you understand this document to be?
A certificate of analysis for gas face.
And what type of product is being tested in this analysis, and where can you find that on this page?
The matrix says plant, which is right in the middle of the top header.
What is the date of this analysis?
Date received and also date issued. Date issued for the certificate of analysis is 1-20 or 1/24/26, and it also says the date received 1/14/2026.
So sometime between 1/4/2026 and 1/24/26.
Yes, sir. 1/14, January 14th and January 24th of 2026.
Can you tell from the certificate of analysis what testing method was used to conduct this analysis?
Yes, sir. The method reference is Hemp profile, SDP HPLC, high performance liquid chromatography, Hemp by UV detection.
So I believe we talked about liquid chromatography earlier. Is this method a permissible testing method?
Yes, sir.
What is the reported percentage of delta 9 THC in the sample?
0.022%.
What is the reported percentage of THCA in the sample?
I'm sorry, I was reading the wrong column. The mass percent column, so percent by dry weight mass for delta 9 is 0.279, and you asked for THC acid, which is 30.642%.
So we're under the mass percentage column. Does this report provide a total TWC?
Total THC?
Sorry, total THC.
Total THC, yes, sir, 27.152.
How does this report on plaintiff's website calculate total THC?
It's shown at the bottom left with the total THC equals the THC acid times the 0.87 conversion factor plus the delta 9 THC.
Is that the same conversion formula used to calculate total THC when conducting pre-harvest testing of hemp?
Total THC delta 9, yes.
Is that the same conversion formula used to calculate total THC delta 9 under the final rules?
Yes. If I may add, it is one option that is in our rule allowed. As I said, with liquid chromatography, this conversion factor would be used. If they choose to use gas chromatography, it would already represent the delta 9, including THC acid in the delta 9. So there are two options.
Thank you. So what is the total THC delta 9 percentage in this analysis?
This analysis also adds delta 8, but it said delta 8 was not detected, so the sum would be the THC delta 9 and the THC acid.
When you say it was not detected, how are you able to determine that?
In the column for delta 9 THC, it says ND, which refers to not detected. Again, just trying to clarify, total THC could include a large variety of tetrahydrocannabinols, THCs. With the total delta 9 THC, we're typically referring to THC delta 9 specifically and THC acid, but not other THCs.
So you talked about how the total THC, you've combined the delta 9 THC and the THCA. Can you explain what this total THC level means for someone consuming this product?
Again, total THC delta 9, if I should specify that, because other THCs,
Objection, Your Honor. We, Blanca Foundation, we don't know how the person's consuming the product.
Sustained.
Let's shift to another type of product. Could we go to Defendant's Exhibit 6, which has already been admitted? Could we go to the bottom of the page, showing the URL? Dr. Stevenson, can you read the URL at the bottom of the page?
for UILs, do I need to repeat HTTPS, or may I just refer to the rest of the URL?
I think we can skip that for the sake of the court's time.
Yes, sir. Elevate1tx.com /concentrates.
What do you understand this exhibit to show?
Bulk concentrates.
What is a bulk concentrate?
It describes a product paired seamlessly with THCA or CBD products, is what it describes.
Can we go down to what's the name of the fourth product listed?
Passion orange guava, parentheses batter.
And can you read the name of the sixth product?
Mac 1, parentheses sugar / crumble.
What is your understanding of the word batter to indicate?
Potent product.
What is a sugar crumble?
It could be a variety of products.
Object, this is calling for speculation.
Sustained.
In your time in the consumer protection section of dishes, have you come across hemp extract products before?
Yes.
When you've come across these products before, in what sort of products have you seen them be included within?
Edibles and smokables, flour. Many of the products that are offered for sale in our registered hemp establishments.
You mentioned smokable. What would happen if this product was smoked to the THCA in the product?
Object. Black Foundation also calls for speculation. And
He's previously testified regarding the conversion of THC under heat to Delta 9 THC.
I'm gonna sustain that objection. But you may ask more questions.
Can you please read the blue text on page 2 of Exhibit 6? the blue font at the top of the page.
Oh, I'm sorry. It's COAs for bulk concentrates.
And there appear to be 4 images below. What do these images appear to be?
The one on the right says certificate of analysis at the top. The others, I'll say certificates of analysis at the top.
Let's take a look at those. Let's go to Defendant's Exhibit 7, which has already been admitted.
This was number 5, right, Mr.? What was the number on this?
7.
No, this is defense.
Defendant
7.
7.
7, okay, thank you.
What does the title of this document indicate that it is?
It's a certificate of analysis.
Prepared by who?
Badger Labs. Yes.
What is the name of the product being tested, and where can we find that?
Right under the address in the top description, it says sample name MAC1 THCA extract.
And is that the name of the product that we just saw on Exhibit 6?
Was MAC1 was one of those products listed.
What type of product is MAC1, and where can we find that on this sheet? If we go up. Oh, okay. What is the date of this analysis?
The report date was 10/13/2025.
And what testing method was used to conduct this analysis?
It's a combination. It has the analysis method number, and then it says by HPLC liquid chromatography.
And is this a method a permissible testing method?
Yes, sir.
What is the reported percentage of Delta 9 THC in the sample?
.0868.
What is the reported percentage of THCA in the sample?
79.197%.
Does this report provide a total THC?
Total THC says 69.542%.
And how does this report calculate that number?
It's using the 0.87 or 0.877 or the 87% conversion factor for THC acid plus the THC delta 9 for the total THC.
And that's the conversion formula available under the final rules?
Yes, sir.
If the THCA in this product was exposed to heat, we'll say fire, what would happen to it?
Your Honor, I'm object. This calls for expert testimony, Your Honor. It's also lack of foundation and also hearsay.
It's not hearsay, it's a statement of a party opponent on a pre-admitted exhibit. Dr. Stevenson has testified on the conversion of THCA to Delta-9 THC without objection. This is just a practical application of that question.
Anything else?
You know, Your Honor, I would say that he can read the report, but what it means would require him to be admitted as an expert, Your Honor, and he has neither been designated nor do we have proper foundation for that.
The objection is sustained.
Dr. Stevenson, do you ever bake baked goods in the oven?
Yes, sir.
Have you ever made brownies before?
Yes, sir.
When you baked brownies, approximately what temperature did you bake those brownies?
I don't object to relevance, Your Honor. We're not talking, I don't even know what kind of brownies we're talking about. Infused or regular Betty Crocker.
Well, I think I'm going to let him continue. I think he's trying to get there and asking overruled.
Okay.
You can.
350 to 375.
And previously you testified that THCA converts to Delta-9 THC at, when exposed to heat, approximately what heat?
Your Honor, I'm going to object. Number one, that calls for an expert conclusion, Your Honor. Number two, lack of foundation.
Sustained.
Let's look at another of defendant's product, or of plaintiff's products. Let's go to defendant's exhibit 8, which has been admitted already. So we've got another certificate of analysis. What is the product name here?
Orange guava. Passion orange guava.
And have we seen this product name before on a previous exhibit?
Yes, sir.
What type of product is being tested in this analysis?
It says passion orange guava. I believe the
Yeah. What is the date?
report date is February 9th, 2/9/2026.
What is the reported percentage of Delta-9 THC in this sample?
0.109%. I'm sorry, 0.019% Delta-9.
And what is the reported percentage of THCA in the sample?
75.526%.
And by what method is total THC calculated in this report?
The method was high performance liquid HPLC, liquid chromatography. And it just specifies that the total THC includes the 0.87 conversion factor for THC acid plus a Delta-9 THC. So the total THC combines those two.
And what is the total
Analytes.
THC?
66.338%.
Let's look at another type of product. Let's go to defendant's exhibit 11, which has been admitted already. Dr. Stevenson, in your time at Consumer Protection, have you ever seen a product like this?
Personally, no. I've seen reports on these products.
What sort of reports?
Pre-rolls.
In your time at Consumer Protection, have you been made aware of how this product can be consumed?
Objection, Your Honor, calls for a hearsay response like foundation.
It doesn't necessarily call for hearsay. He can have informed himself in many ways.
Well, he says he's never seen the products.
Sustained. Move on to the next question or rephrase.
Have you ever used lip balm before?
Foot balm.
Lip balm?
Lip balm. Yes, sir.
Does this product appear to be intended as a balm?
No, sir.
Can we go to Defendant's Exhibit 12, which has been admitted? So, what is the website indicated on this image?
www.texashighcouncil.com. Confetti cake.
Do you know whether Texas High Council is a plaintiff in this action?
I do not know for certain.
So we have Texas High Council, and then what is listed below that?
Confetti cake, hybrid 25%. And then a QR code.
And what is on either side of the QR code?
Texas High Council.
Can we go to, let's follow the link on the image and go on the QR code and go to Defendant's Exhibit 13,
What?
which has also been admitted.
Yeah, I thought they were.
So this is Texas High Council's website. Can we go to a bottom left side of the page? Can you read the URL of this page?
Were
Yes,
these-
sir.
I'll just point out, these exhibits may not have actually been admitted because I don't think our client testified to that. But,
This was a pre-admitted exhibit.
Yes, what was the number again?
13.
Yes, this was previously admitted, P13. Every
D13.
time the state is bringing up an exhibit, I am checking my list to make sure that they were pre-admitted. But it would be helpful if you said, I'm showing you what's been previously admitted as P13.
Apologies, I
Which
thought I had been doing that,
You
but I will
may
be
have
more.
said it,
I'll be more prominent.
yes, you may have said it with one of the others, but just presenting it that way, that is our cue, all of us, to look at our list and make sure it's matching.
So we're on Defendant's Exhibit 13. Doctor, can you please read the URL at the bottom of this page?
www.texashighcouncil.com/pages/lab test results.
We go to the first bullet on the page.
The first bullet,
What does that say?
cannabinoid profiles, precise measurements of THC, CBD, and other cannabinoids.
Go down to the next page. So we've got more certificates of analysis. Let's just go with the this one. So what is the sample name on this certificate of analysis?
certificate of analysis, Badger Labs' sample name is Blue Andes.
And do you understand that to be the product being tested?
Yes, sir.
And what method is used to conduct this analysis, this certificate of analysis?
This is high performance liquid, HPLC, liquid chromatography.
What is the reported percentage of delta 9 THC in the sample?
0.2038.
What is the reported percentage of THCA in this sample?
26.495.
Does this report provide a total THC?
Yes, sir.
And what is that?
It reports 23.44.
And how does this report calculate total THC of 23.440?
It uses the 87.7% conversion of THC acid combined with the total with delta 9 THC to provide that total THC.
And that's the same conversion formula used to calculate total THC under the final rules, or one of them?
Yes, sir. It's one authorized method.
Yeah, I know.
So we won't do every flower. Can we go to page 11? So we have this is a strip analysis from Bluebonnet Labs. What would the sample name here be, Dr. Stevenson?
Sample D9 Rice Krispie Treats, 20 milligrams, variety of flavors.
And what type of product is being tested in this analysis, and where can we find that?
In the middle at the top header, it says edible D9 Rice Krispie Treats, 20 milligram.
And what was the date of this report?
October 10th, 2024.
And what testing method was used in preparing this COA?
HPLC, liquid chromatography, and has a method number.
What is the reported percentage of delta 9 THC in the sample?
0.2371.
And what is the reported percentage of THCA in the sample? It's toward the bottom.
It says ND under the column ND, meaning not detected.
So the certificate analysis didn't detect any measurable level of THCA in the sample.
And not THC acid, no. THCA, no.
In your time at Consumer Protection, have you come across any edible consumable hemp products?
Yes, sir.
Could you make any general statements about the levels of THCA that you've noticed in these products?
Your Honor, I would object, lack of foundation. This would also call for expert analysis, and he's not been admitted as an expert.
It doesn't call for expert analysis. I'm asking specifically products that he's seen.
You're asking about specifically, what did you just say? Specifically asking about products that he has.
Seen.
See,
Sorry, my voice is going.
But you can raise the microphone a little bit so I can hear you better. I'm going to overrule this objection.
And the question again, have I seen edibles?
In the edibles that you've seen, have you noticed anything about the THC levels in those products?
What?
It's vague and ambiguous, Your Honor.
I have, that is sustained.
Try to rephrase to get back to where I was. In the edible products that you have reviewed in your professional role in consumer protection, have you noticed anything about THCA levels in these products?
Yes.
Again, this is vague and ambiguous.
You're going to have to be more specific about
Have you noticed whether THCA levels are high or low in these type of products that you've observed or reviewed?
Was it higher or lower?
High or low in THCA?
High or low?
Again,
On the
Your Honor.
products that he has reviewed,
Yeah, that you've personally reviewed.
based on what's been admitted? On the report that he's looking at?
No, just generally his experience.
Your Honor, I think that's outside the scope of direct examination. It's also not based on, and there's
It's
no
outside the
foundation.
scope of direct examination.
Well, there's several objections to this line of questioning that I've heard that I have consistently had to sustain, and this one is no different. But you of course may ask more questions.
Yes. Let's just look at a few other edible products. Actually, I think we'll skip past the edibles. We go to we go to page 3, please. One second, Your Honor. Oh, we can take down that exhibit. Let's transition topics. I'd like to talk with you, Dr. Stevenson, about the new fees and inspections. Does DSHS inspect hemp manufacturers?
Yes, sir.
Does I'll say dishes. Does dishes inspect hemp retail locations?
Yes, sir.
Approximately how many hemp manufacturers and retail locations are there in Texas?
Combined, approximately 14,400.
Approximately how many inspectors does Dishes currently have to inspect those 14,400 businesses?
7.
Has the number of hemp operators in Texas remained steady since hemp sales were first allowed?
No.
Have they increased or decreased?
Increased.
What does the increasing number of hemp operators in Texas say about the number of tests the agency needs to perform?
They should increase.
How has the number of hemp operators in Texas changed since the implementation of the rules on March 31st of this year?
I believe we had the position authorized, but we hired one inspector, and that's so.
Sorry, let me restate my question. How has the number of hemp business owners in Texas changed since the implementation of the rules on March 31st of this year?
Hemp business owners, since March 31, I'm not sure I have that information.
If I limited that to hemp manufacturers and hemp retail locations, how has the number of those increased or decreased in Texas since March 31st of this year?
I'd have to look at, and I have a number for March before the rules were implemented and a number as of yesterday, and it has increased. But did you mean during that time era, or?
There's no pending question.
Okay.
Prior to the implementation of the new rules, how frequently was Dishes able to inspect the 14,400 businesses?
It would take, I don't have the 14,000 number because that continues to increase.
Say whatever the total number is.
We had been projecting around 11,000 combined, and that would have taken between 6 and 7 years to inspect an establishment once.
Does Texas require a seller of consumable hemp to undergo an inspection before they are issued a license?
I'm sorry, Counsel, would you mind repeating that? My apologies.
Does Texas require a seller of consumable hemp to undergo an inspection before they are issued a license?
No, sir.
Are there any active sellers of consumable hemp in Texas that have never been inspected?
Yes, sir.
If a business opened tomorrow selling cannabis, how long would they be in business before Dishes would determine whether the cannabis they were selling qualified as hemp?
No, that calls for speculation, Your Honor. And
Sustained,
it's also like foundation.
sustained.
What's that? So we've talked about, you testified that it currently would take 6 to 7 years to inspect all the businesses. How frequently is Dishes seeking to inspect businesses selling consumable hemp under the new rules?
Every 2 years would be our target.
What is the importance of regulators doing more frequent testing?
To ensure that the product complies with the regulations and the statutes.
I pass the witness.
All right, thank you, Mr. Berg. You may come up, Mr. Sergi.
Your Honor, is it a good time for a break?
Oh, yes, it is. I forgot. Let's go ahead and take our morning break. We can go off the record. Back on the record, Jan 26-00-2511. You may proceed, counsel.
Dr. Stevenson, my name is David Sergi, and I'm one of the attorneys in this case. I think we've met before.
Good to see you, David.
So-
Yes, sir.
It is nice to see you again. Couple of questions. First of all, you're not testifying as an expert in this case, correct?
Correct.
Thank you. And you're not an economist, right?
Correct.
Okay. And matter of fact, back when you and I were both at Texas A&M, you couldn't take a class on cannabinoids or hemp at Texas A&M back in the day when we were both in the College of Agriculture.
I believe that's right. Yes, sir.
Matter of fact, we might have been arrested for that. Okay. Now, you understand that the injunction that we are seeking does not challenge the 21 plus age gating. We are not asking.
Yes, sir. Yes, sir. I understand that.
And it does not challenge the labeling requirements that you propose.
Yes, sir.
And it does not challenge the mandatory warnings, statements that will be required. We're fine with that. You understand that?
Yes, sir.
Businesses would still have to get licenses, correct?
Yes, sir.
Or be registered. And the final products would still be required to have full panel testing and be tested for various cannabinoid concentrations.
I'm sorry, could you say that again?
We're not objecting to the testing requirements in and
okay.
of themselves.
Yes, sir.
And you understand that we are not challenging the department's authority to require testing and disclosure of total THC.
I'm not sure about that. I thought the THC acid was a concern, including the THC acid.
You understand, we don't object to testing, so there's transparency to the consumer, to law enforcement, and to regulators.
So if I could clarify, you don't object to testing, but to the definition, the limit?
Yeah, in other words, what we are complaining about is more the application rather than the testing.
Mr.
You're up.
Berg is standing behind you.
What?
Yes.
It's hard to get over Mr. Sergey.
I'm sorry.
It's very, very tall. I'd object. The witness is not here as a party representative. He's here as a fact witness.
Okay.
I don't think he needs to testify as to the plaintiff's petition.
Okay.
Let's move on to the next question.
I will. And you understand that from our position, you can still go after bad actors.
Yes, sir.
I have no further questions. Thank you.
Thank you. Mr. Berg, anything else?
Very quickly, Your Honor.
Okay.
Could we pull back up Defendant's Exhibit 7, which has already been admitted?
All right. 1 second to move the controls here. You just push and hold quickly, maybe 2 seconds. There it is. Okay, this time it's working very fast.
Could we go to the top of the page? So you recall this, when we talked about this earlier, the certificate of analysis for the MAC1 THCA extract?
Yes, sir. Yes, sir.
Could we go down to the weight percentage testing results? Would you remind the court or can you go down to the testing method, please? What was the testing method on this again?
There's an analysis method number, and then it says by HPLC. That is the method.
And that is a valid method under state rules for determining THC delta 9 content.
Yes, sir.
And what was the total THC weight percentage result in this test?
69.542%.
And is 69.542% higher than 0.3%?
Yes, sir.
Pass the witness.
All right, thank you. Anything further?
No, Your Honor.
All right, thank you. You may step down. Thank you, sir. You may call your next witness.
The defendant's rest, per prior agreement, I think we should move to closing arguments.
Okay. Would you want to proceed now, or do you need a break prior?
I think I'm ready to go, Judge.
Okay, Mr. Snell, come on up.
Your Honor, before I proceed with my closing argument, I do want to, again, talk about our request with respect to the order in which the orders may be signed. And so, we again request, the plaintiff's request, that you hold back any order on the plea to the jurisdiction until you have signed an order and had it entered, had that order entered on the request for the injunctive relief, so that this court doesn't lose jurisdiction on a potential appeal of the order on the jurisdictional motion. So I know that's been said before, but
I was about to say, I heard the request the first time.
okay. But for our own stress levels, I had to say it again. I appreciate
Mr. Berg is standing, so do you have an objection?
No, just to comment on that, as long as the PTT ruling doesn't come after the TI ruling, I think defendants would be fine with that.
I didn't hear the first portion of what you just said. Would you repeat yourself?
My friend on the other side was asking that the PTJ not be ruled on for the TI. I was saying that as long as the PTJ wasn't ruled on after the TI, that we'd be fine with that.
Okay.
That's exactly the opposite of what we're requesting, so I'm not sure I
I think he was
understand.
trying to suggest simultaneously, Your Honor.
Okay.
Yes.
I'm clear on the requests on both sides,
Okay.
both sides.
May I proceed, Judge?
You may.
I want to start off, Your Honor, by thanking the court and your staff for your time. I know this has been a significant time spent on this very important matter, and we are, I think I speak for all the attorneys and the litigants, very appreciative of that. And I also want to thank the state's attorneys, Your Honor. I can't express enough how civil and professional and extremely competent they have been, and it has been a pleasure to work with them. And Mr. Berg, in particular, who I view as the quarterback of that team, I want to thank Mr. Berg. It's really been an honor to work with them. And it's important that I say that because we don't always get to say that, but that's certainly the case in this important matter. Your Honor, in the plaintiff's view, this case presents a straightforward but important question. Can an agency replace the legislature's regulatory framework with its own and enforce that new framework across an entire industry without statutory authority? It's clear, as established through our briefing and through the evidence, that the answer is no. The evidence presented in this hearing shows that across every category of the challenged rules, that is exactly what has occurred. And Your Honor, you heard Ms. Taylor state in opening statement that this is a separation of powers case. And that's exactly right. It's not a policy case. We're not asking you to determine who's right or who's wrong with respect to the hemp industry. That's for the legislature, and the legislature has spoken. But what you have heard through the evidence and from the witnesses, that over a 7-year history of Texas's consumable hemp program, the legislature has considered, but has never enacted, any amendments to the statutes governing the commercial sector of this industry. You heard Mr. Fowler, Mr. Bordas discuss what happened at the Capitol and the efforts that were unsuccessful to amend the statutes that remain in effect. And that's important. That goes to the heart of this separation of powers case. You've also heard evidence that the 2026 rules effectively do what the legislature could not do. Mr. Bordas testified that the 2026 rules effectively do what the governor refused to do when he vetoed SB 3 in 2025. What happened is this: the agencies kept the statutory definition of hemp as being based on actual Delta-9 THC at or below 0.3% on a dry weight basis. But they enacted a series of rules, the rule makers enacted a series of rules that impose a total THC compliance standard that prevents hemp materials from being imported for use in the manufacturing and processing, and make a large majority of the existing finished products, which are completely legal under the statutes, illegal under the rules. And you heard plenty of evidence about that, Your Honor, that these illegal rules, Frankenstein, legal products, bath bombs, ointments, balms, other products, pet food, these products become illegal under the rules. And that's exactly what the rules cannot do. That's why they're illegal. As elected officials, the members and representatives of the Texas legislature must answer to the voters of Texas. That's just politics 101, political science 101. We all know that. That is a fundamental check and balance of our system under Article 3 of the Texas Constitution. Again, we don't need to be reminded of that. We all know that. But what's important and what's incredibly relevant in this case, in the issues before Your Honor, is that appointed agency bureaucrats lack accountability to the people of the state of Texas. And that's why their authority is limited. That's why their authority is limited. There is no accountability. And when the bureaucrats write rules that dismantle an entire industry with the stroke of a pen, the people of the state of Texas have no recourse except to vindicate their rights in this court, in Your Honor's court. And that is why we brought this lawsuit. That's why we're here today. And you've heard this evidence. You've seen the documents. And you've seen the real life stories of the people who have walked in and sat on that bench under oath. And frankly, that is why major policy decisions in the state of Texas like this must be left to the legislature and not the agencies. And because the agencies have overstepped their authority and attempted to legislate through rulemaking, again, that's why we're here today. In your court, asking you to make what we know are big decisions, Judge. And we recognize that. But Your Honor, as Your Honor is fully aware, you know, and we know that is your role in this check and balance system. You are the final check and balance. And we recognize that we're asking you to enter an order that will affect millions of Texans. Likewise, we're asking you to enter an order that will save a rippling course of economic devastation, other types of harm, from likewise rippling across the state of Texas and the lives of millions of Texans. And we know that is a big decision. It's a big ask. But we think it's the right decision. And it's the right decision for a very simple reason. It's the right decision because of the separation of powers. The statute is the statute, and the rules cannot change them, and that's what they've attempted to do. And I'm going to explain to you now in four main parts in this summation, Judge. First, I'm going to talk about how the challenge rules fall into the four categories reflected in the proposed order that we're asking you to sign. It's a long order. I recognize that. And Your Honor has a copy of that. So I'm going to talk about how the challenge rules fall into four categories.
I have your proposed order pulled up
Thank you, Judge.
so you can discuss it.
And I'm going to then talk about how each category supports plaintiffs' three causes of action and why the temporary injunction elements are satisfied. And finally, why the scope of relief is requested and is necessary and appropriate. So first, how the rules fall into four categories. So, and I know you've heard 3 days of this, Judge, and you're familiar with this. But the challenge rules operate in four ways. First, they replace the statutory THC standard, and that's the 0.3% versus the total THC that we've discussed. Then the rules restrict the transport of upstream materials, so the transport of the upstream materials. And then the increased fees, the 5,000, the 10,000, the per location, the per manufacturer, per grower, those fees. And then finally, the escalating penalties without the statutory safeguards. And those are the four categories of rules that we challenge. And these four categories are not just organizational, but they reflect how the rules function in practice and how they're challenged in the petition. So our first cause of action, Your Honor, is ultra vires, which the governing principle is this, and it's a basic tenet of law. An agency may adopt rules to implement a statute. We know that, and that is what agencies do. But what an agency cannot do, and what the rules cannot do, they cannot conflict with the statute, and they cannot expand beyond what the legislature authorized. They cannot expand beyond what the legislature authorized and cannot conflict with it. So on the one hand, we have the statute. On the other hand, we have the rules. The rules are limited by what the lawmakers have enacted. Here, the rule makers have overstepped. Ultra vires. First, the first category is the total THC testing framework. Now, the legislature was very careful in defining hemp using a specific compliance standard, and that's the Delta 9 THC at or below 0.3% on a dry weight basis. Now, the rules impose something quite different, and that's the total THC or acceptable hemp THC level standard based on conversion methodologies. And these are conversion methodologies that Mr. Stevenson discussed and Dr. Stevenson discussed and that Dr. Holmes discussed when she was on the stand. Now, on that subject, you were shown GA 56, which was signed by Governor Abbott's office, where there was a discussion of a request that testing methodologies be utilized. And we don't challenge that. We don't challenge consumer transparency. And that was discussed in the last witness you heard. Plaintiffs do not challenge the need or the desire that there be as much transparency as possible. It is replacing the testing framework for the entry of the product into commerce that we challenge. That's what changes the statute, not the fact of the testing. It's how you use the testing. And we were very careful in how we crafted our petition in that regard. So I want to be very clear on that. This total THC methodology as a gateway for product to get into commerce, into consumers' hands is, and you heard it through the witness testimony, has real world consequences. Again, it makes lawful products unlawful. Under the statute, products that were heretofore lawful get Frankensteined into unlawful products. And we've shown you absurd examples, and they're not all as absurd as dog food or cat treats, but there's some that are equally absurd or at least come close. Essentially, the compliance is measured differently than what the legislature required, than what the statute required. Business operations are going to have to change to meet this new statutory requirement. You heard that through Mr. Berner and our other Lauren from Longview and Melanie Carpenter. You heard testimony about how their businesses will be affected based on this unlawful statutory requirement that has been injected into the rules that's greater than what the statutes either require or the law allows based on the ultra-virus theory. And that is exactly what the relief that plaintiffs seek with respect to the testing compliance, to prevent the enforcement of rules that condition lawful activity on a non-statutory, unlawful THC standard. That is what we're asking your Honor enter with respect to the injunctive relief under the ultra-virus theory with respect to the THC under this new standard, this unlawful standard. Next, I want to turn to the transport and material restrictions. That's the second category of rules. And that simply is this. The statute regulates finished, consumable hemp products, but the rules go further and restrict raw hemp ingredients and other materials intended for further processing. Again, we see an overreach. The rules go further than what the statute allows. We're asking your Honor to enjoin that. Texas law and federal law protect the transport of certain materials and govern that. The rules go further. All of this has an operational impact. If the transport, the second category, you see disrupted supply chains, the prevention of access to inputs or ingredients or other materials needed, and interfere with manufacturing and process. So you heard from Mr. Berner, you heard from Lauren in Longview that essentially these rules have gone into effect and it stopped their operations. Mr. Berner testified that he invested $100,000 in a facility that he can't operate. It's on hold, that he's bleeding monthly on the carrying costs. These have real non-hypothetical impacts on not just these plaintiffs and their businesses, but businesses and in the hemp industry all across the state of Texas. And you heard the testimony of Bo Whitney with respect to the impact that not just this category, but the other harms that we complain of, the ripple effect, the billions of dollars in lost revenue to the state of Texas, the lost jobs, the lost tax revenue, all the economic harms that are going to and have already occurred, but will occur if Your Honor doesn't sign the temporary injunctive relief. So that is another category we ask Your Honor restrain. So essentially, the new rules interfere with the statutory pathway that the legislature created for this industry to operate. So this category cuts the knees out from under the industry and begins the crippling process, and it's just part of the crippling process for this industry. The next is the fee provisions that you heard about. Again, that's the $5,000, that's the $10,000, the annual fees, the licensing fees, the registration fees, the renewal and change of ownership fees that we've challenged as ultravirus. And you heard testimony on all these points about all these fees and the significant and damaging impact these fees will have not only on these plaintiffs, but on the entire legal hemp industry and on Texas, because you're essentially going to create a barrier or a hurdle for entry into not only an entry into this industry, but a barrier to those that are in the industry from staying in it. So, Your Honor, you think about the mom and pop businesses all across the state of Texas who have found their way into the hemp industry, invested their life savings like Melanie, like Lauren, like Kenneth Berner, like other Texans all across the state. And I'm going to get to this in a minute in a little bit greater detail, but the $5,000, the $10,000, are these fees designed to the purpose behind these fees? The purpose behind these fees, and you heard Mr. Bordas say, it's a draconian fee, and it's designed to do what the governor refused to do when he vetoed SB 3, is to kill the industry, to stop it, to keep this industry from functioning for the good Texans who invested not only their lives, but their life savings. The evidence shows, and it was abundantly clear through the testimony of Bo Whitney, the evidence shows that these fees are not tied to any regulatory cost. Not even close to it, Judge. Not even a close call. But instead function to raise revenue, to stymie and prevent in a draconian fashion to essentially destroy an industry. That's what they're doing. And that's why we need this temporary injunctive order. And finally, with respect to the different categories, the penalty structure, the statute requires a notice, an opportunity to cure for an unintentional violation, but the rules do something different. The rules don't allow for any of that. The rules impose daily accumulating penalties without any meaningful cure provisions or opportunities, and that directly conflicts with the statutory scheme. So with respect to all 4 of these categories that we've carefully pled, Your Honor, the rules impose requirements not found in the statute. They prohibit conduct that the statute allows, and they alter the legislature's framework, which is what they are not allowed to do, and what the legislature has not done, And that's ultra-virus, Judge. That's ultra-virus, and that's illegal. That's unlawful behavior, Judge. And that's why we're here. And we ask Your Honor to sign a temporary injunction to enjoin that illegal and unlawful behavior. Now I want to turn to the constitutional claims that we've crafted and that are contained in our proposed temporary injunctive order. And the same provisions also raise constitutional concerns, Your Honor. And let's talk about these fees. And I talked about this a moment ago. So these draconian, ridiculous fees, they exceed the regulatory costs. They raise revenue. And when that happens, it becomes a tax. It becomes a tax. And you heard that through Bo Whitney. You heard that through Mr. Bordas, that these fees bear no relation to the regulatory oversight. And when they become a tax, they violate the Texas Constitution, Article 8, Section 1C. Agencies do not have authority to impose taxes. Agencies do not have authority to impose taxes. They do not have the authority to do that. It's what the lawmakers do, but that's what they've done. That's what they've done. The penalties also are excessive and unlawful, and there's a prohibition in the Texas Constitution that prohibits excessive fines. The penalty structure accumulates daily violations, lacks procedural safeguards such as notice and opportunity to cure, and again, they lack proportionality. And you heard evidence of that through Bo Whitney and Mr. Bordas. And then the petition challenges those fees on these grounds as well. Those violate the Texas Constitution, Article 8, Section 13. The lack of the notice and opportunity to cure with respect to the fees violates due process rights of everyday Texans, and that violates Article 1, Section 19. You've heard a lot about the APA. It took me a while to figure out what that was when I started working on this case about a month ago, the Administrative Procedure Act. Now, Your Honor, we have a lot of good claims. I'm very fond of them all, but this one is also a silver bullet, frankly. This one is also a silver bullet. The rules fail themselves under the Administrative Procedure Act. So what does the Administrative Procedure Act require? The petition identifies a failure to provide the required economic analysis, a failure to consider less burdensome alternatives, and a failure to respond to statutory objections. Fail, fail, fail. There's plenty of evidence that we win under the Administrative Procedures Act, Judge. If Your Honor can get to the relief that we asked just on that basis alone. The agency acknowledged that it has acknowledged a significant economic impact, and you saw that evidence. But they did not, the agency did not follow the procedural safeguards required in such a situation. Did not substantially comply. Frankly, there wasn't even an attempt. Wasn't even a laughable attempt, Judge. Why? Why didn't they? I suggest to you the evidence is clear on that point. They're trying to kill the industry, not follow the law. That's the effort here. That's the effort here. I'm going to get back to that in a minute. Have we shown a likelihood of recovery on probable, imminent, and irreparable injury? And, Your Honor, I believe there was plenty of compelling evidence on this point. You saw evidence of, through our witnesses, operational disruption, supply chain disruption, product removal and reformulation if this injunctive relief is not entered, and frankly, has already occurred beginning on March 31st and during the time before the TRO was entered, and increased compliance costs. So irreparable harm. You've seen that. You heard that through Mr. Berner, through Melanie, through Lauren, certainly through Mr. Whitney. And frankly, Mr. Fuller showed this irreparable harm as well through his very compelling testimony. And why is this? These harms began right when these rules took effect, and you saw that. You heard testimony of the immediate decline in revenue, the confusion in the marketplace, the inability of these retailers to service their customers, to provide the service, the community service that they believe they provide, and you saw evidence that they do provide. You heard Mr. Fuller so compellingly discuss the impact on his brothers and sisters and the combat veterans, that constituency, their immediate harm on all of this. That's immediate. That harm began happening, is going to continue to happen unless Your Honor enters the injunctive relief. And these aren't hypothetical harms. Absolutely not hypothetical harms. The economic impact alone through Mr. Whitney shows you that these aren't hypothetical harms. Mr. Berner's testimony alone that brought tears to his eyes when he discussed the immediate kind of treatment or services that his customers need that they would be deprived of. That's not hypothetical harm. Mr. Fuller certainly did not describe hypothetical harm. Melanie Carpenter, who discussed her life savings that she and her husband have poured her heart and soul into, that's not hypothetical harm. Lauren on Longview, who puts a table in the square in Longview, Texas, and services veterans in her community and others who need her help. That's not hypothetical harm when that goes away. That's not hypothetical harm when her life savings is lost. And that's the kind of harm that we have seen already, that we're going to continue to see, Your Honor. And not just with the people who were able to be here today. They were able to travel here, not just today, but this week. Texans all across the country, all across the state, in every corner of the state. Every corner of the state. And you don't have to take my word for it. You can take the word of Bo Whitney, who talked about the statewide disruption and crippling economic impact that these unlawful rules trying to destroy an industry are going to do to Texans in the state of Texas, whose favorite motto is we're open for business. And has been open for business, frankly, with the legal hemp industry for 7 years now, until the rulemakers decided to do what they're trying to do and kill it. This harm is immediate. It's happened already, and it's going to happen again, Judge. This harm took effect when the rules began to happen, when the rules took effect, and you heard that. And Judge Gamble heard just a part of this about 2 weeks ago, 2.5, 3 weeks ago, when she entered her temporary restraining order. And she found that there was sufficient concern about immediate and ongoing harm to warrant interim relief. But Judge, you have had the opportunity of the benefit of a fuller record on this, on these same issues, The harm, certainly the economic harm, and frankly, the other types of harm that I've described is irreparable. And that's our burden to show, Your Honor, that the harm is irreparable. And we've done that. We've talked about the potential closing of businesses, the reduction of employee hours, the shuttering of a manufacturing or growing facility, the decline in revenue, the inability to service customers, to provide the needs that these people have. We've shown you the market disruption, the relationships destroyed, the product on the shelves. They're going to have to be tossed forever. The money lost forever. That's irreparable. Well, why is it irreparable? It's irreparable because there's no adequate remedy at law for any of these harms that we've shown, Your Honor, have happened or will continue to happen because of sovereign immunity. We cannot, these people cannot go sue the state of Texas for damages. They have no right. They have no ability to do that. And so this is it. This injunctive relief is it. So this damages are not available. And again, we get back to this big ask that affects millions of Americans, tens of millions of Americans. I think it's one of the world's largest economies, an $11 billion industry within one of the world's largest economies. So what are we asking you to do, Judge? What are we asking you to do? We are not asking you to do something different. We're not asking you to do something different. We're asking you to maintain the status quo. The state is asking you to do something different. These fine attorneys on the other side are asking you to do something different. We're asking for the status quo. So what is the status quo? The status quo is let's keep in effect the laws, the legal statutes that were in effect, that have been enforced pre-March 31, 2026. That is the status quo. The statutory framework that existed before the challenge rules took effect. Return us to the status quo. What does our relief do if granted? What does our relief do if granted? It does not create a new system. We're back to the system that's in place now, that's been in place for 7 years. It preserves what the legislature has enacted. It preserves what the legislature has enacted. Which brings me to my next point. What happens if you don't? What happens if you don't? And what happens if you do? What happens if you do? And I know, Your Honor, this is a court of law and of equity. In Texas, our courts are law and equity, so you take into account what's fair. At the same time, you're taking into account the law. And that's a big job, because what's fair means different things to different people. It's certainly, but what does it mean in this case? What does fair mean in this case? What do the equities balance to in this case? Because I know Your Honor has to weigh those. So you weigh the public interest versus the equity that the state seeks and what we seek. If the challenge rules are not enjoined, the significant harm to the plaintiffs, to their business operations, to their consumer relationships, to their rights and economic interests, and frankly, potentially forcing them out of business. And not just the plaintiffs, and not just the hemp industry writ large, but all those affected. And Bo Whitney talked about the rippling impact that ripples outside of the hemp industry. The sales tax revenue, the lost jobs, the money that goes into the economy of the state of Texas and has gone into the economy of the state of Texas for the last 7 years. That is the kind of thing that is at risk and is imperiled if the injunction is not ordered. Market-wide supply chain disruption, growing manufacturing, processing forced out of state, jobs in other states instead of the state of Texas. Consumers turn to less safe, potentially black market alternatives. Consumers who heretofore have had an alternative way to seek the everyday help that they need. And Mitch Fuller is the person, when I close my eyes, that I see and the tears that he had in his eyes when he talks about the brothers and sisters, the combat veterans, his constituents, his fear for them. And frankly, the fear that Mr. Berner expressed and Melanie expressed and Lauren expressed, the fear that they have of what their customers are going to do. And that is a rippling effect that is beyond economic calculus. And Your Honor, being a court of equity, can take that into account. We ask that you do that. And that's beyond anything anyone can fix. Certainly any court of law can fix. If that happens, that's not fixable in any court. And frankly, if that does happen, if those things do happen, the exact thing that the state says they want won't happen. That is when you get reduced transparency, you get unlawful activity, you get people trying to seek help in a potentially way that's completely unregulated. Nobody wants that. I don't really think the state wants that, but that certainly, if you consider the evidence, is a consequence that will happen, a harm that will occur. Instead of going to the retail store with the package, with the age limitations, with the transparency, frankly, that you saw with the state's exhibits. What's in this product? You can make a choice, consumer. You can make a choice. We're following the law. You make your choice. That goes away. That goes away. Mitch Fuller says, Mr. Berner says, the people that are trying to, for instance, limit their alcohol intake, what happens to them? Those are real world harms. That's the sort of thing, that's the sort of consequence that will occur. And that's nothing to say about the loss of, frankly, the loss of sales tax revenue and the other great economic impact for the state of Texas that it has seen over these last 7 years that will be lost. And again, Texas' reputation for being business friendly with predictable rules and good government, what happens to that? What happens to that? It becomes an empty slogan. An empty slogan. That's what happens to that. What happens if the challenge rules are enjoined, Your Honor? What if you do enter this temporary injunctive relief that we're asking you to do, this heavy lift, and we recognize that? Well, Texas continues to responsibly regulate the hemp industry from seed to sale under the prior framework as enhanced by the new 2026 safety rules that are not challenged by plaintiffs. That are not challenged by plaintiffs. I'm referring to the age restrictions. I'm referring to the tamper-resistant packaging. I'm referring to all of these good things, the safe things that we don't challenge, that the industry wants, frankly, and that I suggest that Texans want. We're not asking you. Those things will remain consistent and in effect. And these Texas businesses continue to operate within the state. And then the state of Texas continues collection of significant sales tax revenues, significant employment provided by the hemp industry. All these positive things continue. All of these positive things continue. Consumers, especially veterans, continue to have legal access to naturally derived, safe, regulated products that alleviate anxiety, PTSD, help them sleep, help them to avoid more harmful or harmful chemical substances. The consumers who can make educated choices based on transparent packaging that the state showed you as a part of their case. We embrace that. We embrace that. And that continues. And that continues. And no good Texan shouldn't want that to continue. Undeniably, the equities balance in favor of granting the injunction. Undeniably, when you weigh those equities, Judge, it tilts very far in favor of granting the injunction. And importantly, again, the requested relief does not prevent enforcement of the valid statutory provisions. Does not prevent enforcement of the statutory provisions at all, because they're lawful and they're legal and they go right back into effect, just as they are today. Just as they are today. I do want to emphasize that the scope of injunctive relief that we request is certainly not limited to the plaintiffs in this lawsuit. We're asking for a statewide injunction, and a district court has discretionary and equitable authority to grant injunctive relief against the named defendants where the benefits of the injunction may extend to parties similarly situated to but are not named plaintiffs in the suit. And we've cited those articles of the Texas Constitution, the Texas Government Code, and the Texas Civil Practice and Remedies Code in our briefing, in our pleading, in our proposed temporary injunctive order. And if Your Honor, an injunction, and I'm gonna quote more, the Campbell versus Wilder case. It's a Texas. It's out of the Supremes wrote it in 2016. An injunction must be broad enough to prevent repetition of the evil sought to be stopped. That's their words, not mine. The evil sought to be stopped when a policy or procedure is challenged as being in conflict with state law. If Your Honor does not enter this injunction that's greater than the named plaintiffs, their words, not mine, the evil won't be stopped. The evil won't be stopped. It'll be so limited that it'll be a nullity, frankly. And while the breadth and scope of that kind of relief isn't warranted in all cases, we've established it is warranted here. The Texas cases have recognized that it's appropriate under these kinds of circumstances when necessary to afford complete relief, when the injury shared between the named plaintiffs and others is similarly situated and indivisible. We've shown that. We've talked about the crippling impact on the hemp industry writ large that's greater than the impact just on these named plaintiffs. And finally, when the denial of such relief would result in a multiplicity of suits. If Your Honor limits her injunctive order to just these named plaintiffs, these other non-plaintiffs who are affected will have to go in and file their own lawsuit, and we'll be doing this same thing all over the state of Texas. We don't believe that, we would hope, Your Honor, that you would not do that. Here we have two associational plaintiffs, each with a broad base of members. An injunctive relief would not only apply to the benefit of all their members, but those that are served, but also the industry that they serve. And because the 2019 Texas Farm Bill implemented a comprehensive statutory regime to support and regulate the industry from seed to sale, that includes farmers, manufacturers, processors, distributors, and retailers. Those are all the stakeholders benefited and affected by the 2019 Farm Bill. We would ask that your injunctive order in the form that we have presented to you be entered to protect and benefit and provide complete relief not only to the plaintiffs but to those additional stakeholders, those others in the state of Texas who are governed by the 2019 Texas Farm Bill. And moreover, the injury that would suffer by these affected, not only the named plaintiffs, by the other affected people and businesses in the state of Texas, is individual from the injury of plaintiffs. So again, that's another reason why we're asking for this great relief. And not to say this multiplicity of suits that would, grow like a 17,000 headed octopus if you just limit your relief to these plaintiffs. I'm going to end with this. I'm going to come to a conclusion here. But this is something that has the kind of thing that keeps a lawyer up at night amongst all the other things. This idea of this being a policy debate. I mean, there is a way to look at everything you've heard today as two sides of a policy debate. On the one hand, you have our plaintiffs and the individuals associated with the plaintiff side of this case probably have one view of a policy debate that differs from the state. Fair to say. But there's a distinction between whether it's a policy debate and whether it's a policy debate that matters. I don't think it's a policy debate that matters. To rule in our favor is not to engage in the policy debate, is not for Your Honor to decide that the consumption of these hemp products is the right or the wrong thing to do, is something that's good or bad or is beneficial. You don't have to decide that to rule in our favor. Because we're asking you to rule as a matter of law on the three legal theories that we have set forth, that we've brought forth. There has been a policy debate that does matter. There has been a policy debate that does matter, and that happened at the Capitol. That's the policy debate that Mitch Fuller described to you, Mark Bordas described to you. That's the policy debate where people flooded the courthouse, the Capitol, where people emailed and called their lawmakers. That's a policy debate that has gone on, that should go on, that frankly, is a positive and healthy thing. That's what we do in our civilization. We engage in policy debate, and that informs what kinds of laws are passed or not passed. That's the policy debate that matters. And what happened when the policy debate happened? The legislative framework, the statutory framework that went in effect in 2019 remains in effect. The statutory framework that went into effect after the policy debates went into effect and stays in effect. Respectfully, I think the state wants Your Honor in this court to engage in a policy debate and rule that their side of the policy is right. That their side of the policy is right. I think that's, frankly, I think that sums up. Their position is these products just aren't good, shouldn't be out there, so we're going to change the rules. We're going to take them off the shelves. We're going to kill the industry. We're going to knock them out. We're going to make the fees so high that we win the policy debate that we couldn't win at the Capitol. They want to win the policy debate through arbitrary rulemaking by unelected bureaucrats. And that's not what the law allows. And that's not what Your Honor has to do. You don't have to get down in that mud. And we ask that you not do that. This case is simply about statutory limits and not policy preferences. The legislature made the law and the agencies changed it. They tried to change it. And we called them on it. And that's why we're here. We're here for Mitch Fuller and his constituents. We're here for Kenneth Berner, Melanie, and Lauren, and everybody just like them who've invested their life savings. That's why we're here, because we called them on it. Because they couldn't get it done at the Capitol. So we got to get it done at the courthouse. Your Honor, the record shows there's a strong record. There's an evidentiary record that we think is going to withstand scrutiny, a probable right to relief on every single one of our claims. You pick them, any one of them or all of them. An immediate and irreparable harm, no adequate remedy at law, and that the requested relief is appropriately tailored. And for these reasons, Your Honor, we plaintiffs respectfully request that the court grant the temporary injunction in the form of our proposed order. Thank you, Your Honor.
Thank you, Mr. Snell. It's 12 o'clock, so we're gonna have to break for lunch, and then the state will have an equal amount of time for closing.
The 261st District Court is back in session.
Good afternoon, you may be seated. All right. Ms. Palace, you let me know when you are ready. Let me fix the lighting just a bit.
I'm ready, Judge.
Okay. So the state, are you ready for your closing?
Yes, ma'am.
So it's gonna be you. Okay, Mr. Dustin.
That's correct.
All right, come on up.
Well, if they let these go this high. All right. All right. Can you hear me? Okay,
Yes, sir.
good. All right. And for the record, Jacob Dustin, Assistant Attorney General at the Office of the Attorney General of Texas. May it please the court. There is much, as our friends have said, that defendants and plaintiffs actually seem to agree upon in this case. We both want a viable, consumable hemp product industry in Texas. We both want children protected. We both agree that we want veterans and other Texans suffering from serious physical and mental health ailments to receive the treatments that they need. We both agree that many portions of DSHS's new rules, like those provisions related to age verification, other consumer protection provisions such as labeling, are desirable, well-intentioned, and proper regulations. We both agree that the regulatory framework of Texas's hemp plan, which is federally approved, is an interwoven mesh far broader than a single department or a single statutory chapter. And even on the ultimate points where we do disagree, which is, of course, DSHS's rules defining total THC, among a few other points, there's yet another layer of agreement. We heard that both doctors who testified, Dr. Holmes and Dr. Stevenson, agree on the properties of the cannabis plant which is at issue in this case. Delta-9 tetrahydrocannabinol, or Delta-9 THC, is a psychoactive cannabinoid. Tetrahydrocannabinolic acid, or THCA, is a precursor to Delta-9 THC. THCA can be converted into Delta-9 THC through decarboxylation, or for those of us without several advanced degrees, heating, by just heating that substance with THCA in it. Both doctors even agree on the rate at which this happens, 87.7%. And both agree that THCA is not psychoactive until it is heated and converted into Delta-9 THC. And again, on the law, we agree quite a bit. Both parties agree that the pre-harvest testing of cannabis plants to determine if they qualify as hemp under the Texas Agriculture Code, chapters 121 and 122, requires factoring in THCA into the total THC count. Both parties agree that this requires testing with a post-decarboxylation method to account for the conversion of THCA into Delta-9 THC. Parties even agree that this standard is equivalent to what the rules now require at the later stages in the consumable hemp product industry. So, where exactly is the disagreement? The Texas Department of State Health Services has passed rules regulating consumable hemp products, which ensure consistent standards horizontally across the hemp industry, and provide the funds for the department to field enough inspectors to ensure that those standards are being met, again, across the industry. These rules increase the consistency of Texas's hemp regulatory framework, from field to transportation to manufacturing to sale. Because the new rules require post-decarboxylation testing of consumable hemp products prior to their sale to Texans, the same standard as is required prior to harvest, the same method which plaintiffs use to advertise the potency of their products to their customers, plaintiffs object. Why? Because their consumers want these products that are high in THCA. And that's not difficult to understand. But despite straining to do so, plaintiffs cannot reasonably contend that using the same testing standards used at the harvest stage, the same testing standards voluntarily used by plaintiffs, is somehow bizarre or, as it might say, Frankenstein. This misses the point of the standard in the first place. The bills legalizing hemp limited Delta-9 THC allowable in hemp for the straightforward purpose of keeping psychoactive compounds out of circulation in large volumes. And the rules for testing hemp at harvest, both federally and in Texas, require that post-decarboxylation testing to account for this. The Agriculture Code in Texas limits THCA in hemp plants by factoring in this conversion for an obvious reason. This is not random. THCA can be converted into THC upon ignition, readily, at the spark of a lighter. To suggest that these rules should then simply permit the isolation, extraction, and concentration of such substances which is very strictly limited at pre-harvest, just so long as this is done post-harvest, is an odd claim indeed. At this temporary injunction stage, plaintiffs must show to you that there is a probable right to the relief that they seek. This prong is difficult because the law very clearly grants DSHS the authority to conduct rulemaking. Section 443.1051 of the Texas Health and Safety Code not only permits, but requires the commissioner to adopt the rules and procedures necessary to enforce the chapter, which is titled Manufacture, Distribution, and Sale of Consumable Hemp Products. The commissioner's rules must be consistent with the state plan approved by the USDA and must be consistent with the Texas Agriculture Code and 7 U.S.C. Chapter 38, Subchapter 7, again on hemp products. Plaintiffs suggest that the statutes and rules under the Texas Agriculture Code are entirely separate considerations from the statutes and rules, which regulate consumable hemp products. But this is not so. The Health and Safety Code's sole definition of what hemp is simply points to the Agriculture Code. It says that it uses the definition found in Chapter 121. This again shows the interlocking nature of this regulatory scheme. Importantly, the plant, Cannabis sativa, cannot be determined to be legal hemp until it has been tested in compliance with the Texas Agriculture Code and the rules promulgated thereunder. This is the only way to show that the cannabis plant in question meets the statutory definition of hemp. Neither Chapter 121 nor 122 of that Texas Agricultural Code in the statute mention total THC, let alone requiring that term to be inclusive of THCA. So how is the standard achieved? The agriculture codes requiring THC to be factored in, of course, are not an issue at this case, but they come in through administrative rulemaking. 4 TAC 2426C is not simply part of a different statute. It is integral to determining whether a cannabis plant meets the definition of hemp in the first place. Because 443001 defines hemp solely in reference to the Agriculture Code, it cannot be overstated. For the purposes of the later consumable hemp products, the Health and Safety Code is only able to determine whether a cannabis plant or part thereof qualifies as legal hemp based upon the definitions found in the Agriculture Code. Of course, this is also administrative rulemaking, and DSHS has conducted their rulemaking pursuant to a very, very clear and very broad grant of statutory authority. They followed the standard process of notice and comment. They responded to the public comments they received. They made the impact statements that were required. Plaintiffs cannot prove that these are not present. They can only disagree with the thoroughness or the conclusions that DSHS did in creating these. Now, opposing counsel also referred to the APA and Political Science 101, and certainly I do recall testimony from at least one plaintiff, Mr. Berner, that politicians don't know the science about growing or processing hemp, and I'm sure that if this was not on the record, perhaps a greater percentage of the room would be ready to agree. But though the APA did not make Political Science 101, though the APA did not make a great Schoolhouse Rock song, I guess I'm Just an Administrative Rule was just not too catchy. This concern tells us exactly what the purpose of an administrative agency rulemaking is. Both the state and federal governments use administrative rulemaking systems to enable public servants with greater subject matter expertise than the politicians to create the administrative rules which address specific technical subjects. And this is exactly what the Texas legislature understood when they granted that statutory authority to DSHS in Chapter 443051. Those in DSHS with expertise like that of Dr. Stevenson, which we saw earlier today, are able to advise on and pass rules which handle issues requiring more specialized scientific knowledge in the administrative rulemaking process. And the state may, under the federal hemp regulations, be more stringent than the federal regulations, so this is also not an issue. Finally, as to the fees at issue. Earlier, we did hear Dr. Stevenson's testimony. He testified to the rapid growth of licensees under the Hemp program, which was started approximately 6 years ago and now has well over 15,000 participants. The difficulty the department has had, he also testified to, in keeping up with its inspections of this growing field is that they are unable to inspect shops prior to licensing them. They are only able to inspect shops, as Dr. Stevenson testified, approximately every 6 to 7 years. That's about as long as the program has existed. The new fees, and this goes to show because the new rules fees were not enjoined at the TRO stage. That is because the fees, once again, are clearly within the rulemaking authority and discretion of DSHS. Section 12.0111 of the Texas Health and Safety Code expressly allows the commissioner to, quote, collect a fee for issuing or renewing a license that is in an amount designated to allow the department to recover from its license holders all of the department's direct and indirect costs in administering and enforcing the applicable licensing program. With the industry growing so rapidly, the department had to collect these greater licensing fees than what they were set to previously just to keep up with the cost of enforcement. Showing their good faith engagement with the public comments in the administrative rulemaking process, DSHS did reduce the fees from what they had initially proposed. But with these grants of rulemaking authority given to DSHS to administer the consumable hemp product program, the web of state and federal law, which establishes the Texas Hemp Plan, and the department's clear authority to collect licensing fees that are commensurate, plaintiffs are far from showing that there is a probable right to the injunctive relief that they request. Ultimately, the decision in this case is not, we actually agree, again, about policy. It is about whether the promulgated rule, it is not about whether the promulgated rule is popular, perfect, or preferable. What matters is whether it is grounded in statutory authority and whether it is procedurally proper. It's defendant's position that it is. Plaintiffs have not shown that the rules are deficient either in this statutory authority or in this process. As such, defendants respectfully request that this court grant the defendant's plea to the jurisdiction. Deny plaintiff's request for a temporary injunction. Thank you.
Thank you. Anything else? Okay.
Nothing from the defense.
We have nothing further, Judge.
All right, thank you. I want to thank both counsel for the state and plaintiffs for your presentations, your professionalism. You were timely, efficient, and presented in a way that was clear to the court. From the outset, this court told you exactly what it was going to do and the burden of proof that it was going to require from the plaintiffs on a TI and also on the plea. The court will be taking these matters under brief advisement, and you will have my rulings within short order. And are there any other housekeeping matters that you need to discuss with me before we go off the record?
I don't believe there are any from plaintiffs, Judge.
Nothing from the state.
Okay. All right. Well, you all are excused. Have a good afternoon.